Hello everyone, welcome to Legal Darshan. So we are running a continuous series on bringing out the differences between the new criminal laws and the old criminal laws. So we will be picking up a small portion of the act in every video, and we will be deliberating upon it. So you must have seen, we have already uploaded some parts of CrPC versus BNSS and IPC versus BNS already on the channel. Now, earlier we had a discussion on the witness protection, how witness protection provision did not find any place in CrPC, but it has been included in Section 398 of the Bhartiya Nagarik Suraksha Sanhita, the new criminal procedure code. Okay. Now, today we are going to discuss about FIR. Okay, so we are going to dig into in the scope of new law. Where can you file an FIR? How will you file an FIR? That is what we are going to look at in this particular video. Okay, now there are some pertinent changes in section 173. Okay, so section we all know that Section 173 corresponds to Section 154 of the CrPC, which provides for information in the cases of cognizable cases. Now, a very layman idea of CrPC is that offenses have been divided: bailable, non-bailable, cognizable, non-cognizable, right? We all know about it. Now, what happens in a cognizable offense? The police has the power to take on record the FIR and to proceed with investigation without the orders of the magistrate. However, that is not the case with the non-cognizable offense. This is something that Section 154, 155, 156 in the CrPC is already providing us. But now, when we modify in BNSS Section 173 that corresponds to Section 154, there are certain changes that needs to be observed. So, in this video, we are going to look at two things. Where can you file an FIR? Okay. Yeah. First thing is, where can you file an FIR and how can you file an FIR? Because BNSS prescribes one new mode of filing the FIR as well. Okay. Of giving the information, pardon me, of giving the information so that FIR can be taken on record. And in this particular section, Section 173 of Bhartiya Nagarik Suraksha Sanhita, the clause 1 says every information relating to the commission of cognizable offense, irrespective of the area where the offense is committed. Irrespective of the area where the offense is committed are the new words in the language of Section 154 of the CrPC, which is now Section 173 of the Bhartiya Nagarik Suraksha Sanhita, may be given orally or by electronic communication to an officer in charge of a police station, and if given orally shall be reduced to writing. If given by electronic communication, shall be taken on record by him on being signed within 3 days by the person giving it. Okay. Now, FIR, if you have to register an FIR, you do not need to find the jurisdiction of the police station, that this is the particular police station where I shall be registering my FIR. So when we introduce the concept that every information can be given to the officer in charge of the police station, irrespective of the area where the offense is committed, it means irrespective of the area where the actual jurisdiction lie, to any police station you can go and file you can go and get your information recorded. You can go and submit your information orally. Okay. So now this concept is known as the Zero FIR concept. Okay. So now with BNSS, one change that is coming in the CrPC provisions, one change that is coming in the provision which relates to information in the cases of cognizable offenses is the concept of Zero FIR, that now you can go and get your information recorded in any police station, not caring about whether this is the area, this is the particular jurisdiction of the police station where if the offense has been committed. Okay. But when we look at the provisions of CrPC, so Section 154 corresponds to this particular section. And if we read the first clause, every information relating to the commission of a cognizable offense, if given orally, so only orally is mentioned here, not by the electronic communication, and neither it is mentioning that you can go and get your FIR registered at any police station. Okay. So because we are not included the terms irrespective of any area, it means that this section was not actually explicitly recognizing the concept of zero FIR. But now that concept is being recognized by the language of the statute in Bhartiya Nagarik Suraksha Sanhita. So when we talk of where can we file our case, we need not really go to the jurisdiction where the offense happened. We can get it registered in any police station as well. We can get the information registered in every police station, any police station. Okay. Now you need to remember this keyword. This particular provision only pertains to the cognizable offenses. So zero FIR, the concept is introduced by the terminology, irrespective of the area where the offense is committed. This provision is actually safeguarding that, if you cannot go back to your same jurisdictions, for example, if if the victim feels threatened in jurisdiction X and the victim is living with some relative in a jurisdiction Y, she or he can also go there and get the FIR, get the information registered. Okay. Now, what happens when you give the information to the police officer? So either you are giving it orally or you are giving it by the electronic communication. That is the permissible mean, because FIR is the first point of initiation. It is the point of initiation of a criminal proceeding. Okay. It is the beginning of a criminal case. Without registering FIR or without giving information in the case of cognizable offense, how will you proceed ahead? Okay. So it is your starting point. Now, when something is your starting point, how are you going to communicate it? You are either going to, orally go to the police station and you are going to tell what happened with you, or, you are going to register your FIR, submit a copy of your FIR, of your first information electronically. So if you have seen these days, FIR can also be filed online. There is a provision that online information can also be given with respect to the cognizable offenses as well. Okay. So that is why we are including the electronic mode of communication as well. Because these are only ways in which you can give the information of an offense to the police officer. Okay. Now what happens? Who can give this information? You can also give your information if you are the victim, and any other person can also give the information. For example, if let's say that if I am under some threat, okay, somebody has their eyes on me, somebody is keeping a watch on me, on my every action, and I am threatened for my life, somebody who is close to me can also give that information to the police officer. Okay. To the officer in charge of a police station. So information can be given by anybody. It could be you if you are the victim, or it could also be some of your relatives, some of your acquaintances. Okay. Now, this information, as I was just saying, it could be given orally and it could be given electronically as well. Now, what happens next is that this information, once given, once the police officer in charge receives the information, it is his duty to keep it in the records. Okay. So when it is given orally, when your information is given orally to the police officer is going to, the officer in charge is going to, get it reduced to writing, because you have said something orally. Okay. So oral accounts need to be deduced in writing. This will be deduced into writing. It will be read over to the informant. Now the word used here is informant. Informant means anybody who informs. It necessarily does not mean only the victim. That is how you read the language of a code. Okay. Informant can be anyone. It can be my relative, it can be my friend. Right. Now it is read over to the informant, and every such information, whether given in writing, you can also, write an application telling police officer that this particular thing happened with me, or you can go and tell it to him orally. Whether given in writing or reduced to writing as aforesaid, shall be signed by the person giving it. Okay. So once you give the information orally or maybe in writing, police officer is going to get this particular statement deduced in writing. If it is an oral statement, he will be reading the information to you that this is what you have said, we have recorded it rightly, and then you, the informant, he is going to sign that particular information. Okay. So that is how that particular information will be recorded as an FIR. Okay. Now next is, when you are giving it electronically, when you are giving the information by way of electronic communication, because it is a new provision, needs some deliberation, it will be taken on record by the police officer on being signed within 3 days by the person giving it. Okay, so once the electronically your information has been given, so maybe they will call you to the police station to get it signed, maybe they will ask you to electronically sign it within 3 days, and once the information is signed by the informant within 3 days, it shall be recorded in the police station. Okay, so the next line reads, and the substance thereof shall be entered in a book to be kept by such officer in such form as the state government may by rules prescribed in this behalf. So that information shall be kept for records in the record books, and however the state government may prescribe, and that will be taken into account. The main thing that we need to deliberate here is that number one, zero FIR is now explicitly being recognized by the statute, irrespective that, you know, the offense happened in A jurisdiction, I can also go and file a case in the information, I can also give the information in the B jurisdiction as well, C jurisdiction as well. Okay, this is the first thing. Zero FIR concept is there, and by way of electronic communication also your FIR can be registered, right? So these are the two concepts that were important to be discussed, because it marks the beginning of a criminal case. It says that you can get your FIR registered how, where, and when. Okay, how, where, and who. Now, in this concept of zero FIR, we have said that, okay, you can come and get your FIR registered here. Any place, any police station, you can come and you can give the information regarding a cognizable offense, and you can get your information registered here. But what is the issue with zero FIR? The provision is not providing anywhere that you have to transfer the case to the relevant jurisdiction. Okay, this concept zero FIR basically says that I can register FIR at any place so as safeguarding shall be provided to me. But then when we study the concept of zero FIR, it also has to be there that particular information, that particular case has to be transferred to the relevant applicable jurisdiction. But in the language of this section, that particular provision is not there. Okay, now this had to be here because there is a Supreme Court judgment. It is a 1993 Supreme Court judgment titled as State of Andhra Pradesh versus Punati Ramulu. It was actually held that when FIR is registered at any other place, it has to be transferred to the place of the jurisdiction, to the place of applicable jurisdiction to proceed with the investigation. Now, if that transferring provision would have been here, the compliance with the Supreme Court judgment would have been made. But even if it is not there, the judgment is still applicable, and in the same manner that would be proceeding, in the same manner the law would be proceeding with, right? So in this video, we actually culminate here how would you register an FIR. You can go orally, you can also write an application, and you can get it registered in the case of cognizable offense, as well as you can do it electronically. Because, you know, the new laws, they are very, I should say, pragmatic in the sense that they are recognizing the need of digitalization. And for this discussion, we will stop here. In the second part of this discussion, we are going to understand a new provision that is inserted in section 173, which corresponds to section 154 of the Bhartiya Nagarik Suraksha Sanhita, which is about the preliminary inquiry. Okay, now this particular provision, 173 clause 3, this has been added in the section. Okay, it was not there in the earlier erstwhile section 154 CrPC. Now this particular provision gives the power to police to make a preliminary inquiry into veracity of the offense if the offense is punishable with 3 to 7 years of the imprisonment. Okay, now how is it contradicting? How is it flouting the judgment given in Lalita Kumari? That we have to see in the upcoming discussion. We will also be referring to one recent judgment given in the case of Imran Pratapgarhi by the Honorable Supreme Court in the month of March. It was a very well discussed judgment with respect to freedom of expression. Imran Pratapgarhi being a political leader, also being a poet, was in some controversy with respect to his poems, and court took this particular case to elaborate upon the FIR differences between provisions that were in CrPC and right now that is in Bhartiya Nagarik Suraksha Sanhita. That would be the discussion of the second part corresponding to this discussion. To make it very reachable to you, the resources that will be used in such discussions, they will be open resources. Okay, you can also have an access to them, and you can also go and read them out for your own uh, information and knowledge. Thank you everyone for watching. Please stay tuned with Legal Darshan. Have a great day.